Please be seated.
Good afternoon, everyone. Mr. Registrar, could you call the case, please?
Thank you, Mr. President. The Appeals Chamber of the International Criminal Tribunal for Rwanda, composed of Judge Kamel Ejus presiding, Judge Mehmet Gune, Judge Liu Dakun, Judge Andresia Vaz, and Judge Arlette Ramaroson, is now sitting in open session today, Wednesday, the 14th of December 2011, for the delivery of the appeal judgment in the matter of the prosecutor versus, in the matter of Dominique Ntawukulilyayo versus the prosecutor, case number ICTR-2005-82-A. Thank you.
Thank you. Mr. Ntawukulilyayo, can you follow the proceedings in a language that you can understand?
Yes, I can follow the proceedings in French.
Merci. Let's
Thank you.
appearances. Counsel for Mr. Ntawukulilyayo.
Bonjour, Monsieur le Président.
Good afternoon, Mr. President. Good afternoon, Your Honors. My learned friends on the other side of the aisle, good afternoon. The defense is represented by our two assistants, Mrs. Elsa Levavasseur and Maître Céline Relivat, and yours truly, Marufa Jabira from Mauritania, and I thank you.
Thank you. And appearances for the prosecutor.
Good afternoon, Mr. President, and may it please the Chamber. This afternoon, the prosecution team is represented by Mr. Alphonse Van, Senior Appeals Counsel, Mr. Usman Jama, Appeals Counsel, and Ms. Priya Narayan, Appeals Counsel. I am James Arguin, Chief of the Appeals and Legal Advisory Division.
Thank you. Mr. Ntawukulilyayo appealed the trial judgment rendered in this case on 3rd August 2010 by Trial Chamber 3. Pursuant to the scheduling order issued on 10th November 2011, the Appeals Chamber today delivers its judgment in this case. Following the practice of the tribunal, I will summarize the findings of the Appeals Chamber. This oral summary does not constitute any part of the official and authoritative judgment of the Appeals Chamber, which is rendered in writing and which will be distributed to the parties at the close of this hearing. In addition, not every point addressed in the judgment will be mentioned in this summary, which focuses only on central issues. The events underlying this case occurred principally in the prefecture of Butare, Rwanda, in April 1994. At that time, Mr. Ntawukulilyayo was the subprefect of the Gisagara subprefecture within the Butare prefecture. He held this post from September 1990 until he left Rwanda in July of 1994. The trial chamber convicted Mr. Ntawukulilyayo of genocide for the killing of Tutsis at Kabuye Hill within the Gisagara subprefecture. The trial chamber found that he aided and abetted those killings by instructing the Tutsi refugees who had gathered at Gisagara market to move to Kabuye Hill, and by transporting soldiers who participated in the attack at Kabuye Hill. The trial chamber also found Mr. Ntawukulilyayo responsible for ordering the killings at Kabuye Hill. Mr. Ntawukulilyayo was sentenced to 25 years of imprisonment. Mr. Ntawukulilyayo has appealed his convictions and his sentence. He has divided his arguments into 6 grounds of appeal. In his first ground of appeal, Mr. Ntawukulilyayo alleges errors relating to the instructions he was found to have given to the Tutsi refugees who had gathered at Gisagara market to move to Kabuye Hill. Mr. Ntawukulilyayo argues that the trial chamber erred in finding that prosecution witnesses A, Y, Q, and B, A, U corroborated each other, and that it erred in its assessment of their testimonies. He further argues that the trial chamber erred in its assessment of the defense evidence. Accordingly, Mr. Ntawukulilyayo requests that the appeals chamber vacate the trial chamber's findings in respect of the transfer of refugees from Gisagara market to Kabuye Hill. The appeals chamber finds that Mr. Ntawukulilyayo has failed to demonstrate that the trial chamber erred in finding that the testimonies of witnesses A, Y, Q, and B, A, U were consistent with regard to his conduct at Gisagara market on 23 April 1994. With respect to witness AYQ's testimony, the appeals chamber finds no error in the trial chamber's assessment of the alleged discrepancies in her evidence, and accordingly rejects Mr. Ntawukulilyayo's argument that the cumulative effect of such discrepancies renders her testimony unreliable. While the appeal chamber finds error in the trial chamber's assessment of defense witnesses MAD and MAE regarding witness AYQ's role in procuring testimony against Mr. Ntawukulilyayo, it nevertheless considers that such error does not invalidate the trial chamber's decision to rely on witness AYQ's testimony about the events at Gisagara market. The appeals chamber therefore dismisses Mr. Ntawukulilyayo's allegation of error in the trial chamber's assessment of witness AYQ's testimony with regard to Gisagara market. The appeal chamber also dismisses Mr. Ntawukulilyayo's allegation of error in the trial chamber's assessment of witness BAU's testimony about the events at Gisagara Market. In addition, the Appeals Chamber finds that Mr. Ntawukulilyayo has not demonstrated any error in the trial chamber's assessment of the defense evidence that would invalidate its finding regarding his presence and conduct at Gisagara Market on 23rd April 1994. Mr. Ntawukulilyayo has also failed to demonstrate that the trial chamber impermissibly reversed the burden of proof. The Appeals Chamber therefore dismisses Mr. Ntawukulilyayo's first ground of appeal. In his second ground of appeal, Mr. Ntawukulilyayo alleges errors in the trial chamber's findings regarding the events at Kabuya Hill on 23rd April 1994. He argues that the trial chamber erred in finding that prosecution witnesses AZN, AYQ, and BAU corroborated each other, as well as in its assessment of the testimonies. He submits that no reasonable trier of fact could have disregarded the succession of difficulties in and based the conviction on the testimonies. He further argues that the trial chamber erred in its assessment of alleged exculpatory evidence. Accordingly, Appellant Ntawukulilyayo requests that the Appeals Chamber vacate the trial chamber's findings in respect of the Kabuya Hill attack. The Appeals Chamber finds no error in the trial chamber's determination that witnesses AZN, AYQ, and BAU corroborated one another on the category and number of security personnel who accompanied Mr. Ntawukulilyayo on Calixte Kalemanzira's presence at Kabuya Hill and on the vehicles used. The Appeals Chamber also considers that it was within the trial chamber's discretion to accept the fundamental features of these witnesses' evidence, notwithstanding the differences between their testimonies regarding the time of Mr. Ntawukulilyayo's arrival at Kabuya Hill. The Appeal Chamber, therefore, finds no error in the trial chamber's conclusion that witness AZN, AYQ, and BAU corroborated one another in relation to Mr. Ntawukulilyayo's role in the killings at Kabuya Hill. The Appeals Chamber also finds no error in the trial chamber's assessment of the individual merit of the testimonies of witnesses AZN, AYQ, and BAU, or in its assessment of allegedly exculpatory evidence. The Appeals Chamber therefore dismisses Mr. Ntawukulilyayo's second ground of appeal. In his third ground of appeal in part, and his fourth ground of appeal, Mr. Ntawukulilyayo alleges that the trial chamber erred in convicting him for ordering the Kabuya Hill killings. Mr. Ntawukulilyayo argues that the trial chamber erred in finding that he was provided with adequate notice that ordering was a mode of liability pursued by the prosecution for these killings. He further argues that the trial chamber erred in finding that the actus reus for ordering genocide had been established, and that the only reasonable conclusion was that he had genocidal intent. Mr. Ntawukulilyayo accordingly requests the Appeals Chamber to overturn his conviction for ordering genocide. The Appeals Chamber notes that although the indictment put Mr. Ntawukulilyayo on notice that he was generally charged with ordering genocide, the specific paragraphs relating to his responsibility under Article 6.1 of the statute expressly refer only to him instigating, committing, and or aiding and abetting the killing of Tutsis. Paragraphs 7 and 8, which set forth the particulars of Mr. Ntawukulilyayo's participation in the killings at Kabuye Hill, expressly characterize his acts as committing and aiding and abetting the killings. The particulars set forth in paragraphs 7 and 8 do not identify the course of conduct on the part of Mr. Ntawukulilyayo, which would have formed the basis for a charge of ordering the killings at Kabuye Hill. The Appellant Appeals Chamber considers that if the prosecution had intended to charge Mr. Ntawukulilyayo with ordering the killings at Kabuye Hill, in addition to committing and aiding and abetting them, it should have provided an equally clear and precise indication to this effect. Even if the failure to plead ordering with respect to this event could be cured, a review of the post-indictment communications does not indicate that Mr. Ntawukulilyayo was alleged to have ordered the killings at Kabuye Hill. The Appeals Chamber, therefore, finds that Mr. Ntawukulilyayo was not on notice that he was charged with ordering the killings of Tutsis at Kabuye Hill on or about the 23rd of April 1994. Accordingly, the Appeals Chamber grants Mr. Ntawukulilyayo's fourth ground of appeal and reverses his conviction for ordering the Kabuye Hill killings. In light of its conclusion, the Appeals Chamber does not need to consider his remaining allegations of error relating to ordering and to the trial chamber's finding that he had genocidal intent. In his third ground of appeal in part and his fifth ground of appeal, Mr. Ntawukulilyayo alleges that the trial chamber erred in finding that the actus reus and mens rea for aiding and abetting the crime of genocide had been established. The Appeals Chamber considers that it was reasonable for the trial chamber to conclude that Mr. Ntawukulilyayo substantially contributed to the Kabuye Hill killings by encouraging Tutsis to seek refuge there and then providing reinforcements to those attempting to kill them. These acts alone suffice to constitute the actus reus of aiding and abetting. The Appeals Chamber therefore concludes that Mr. Ntawukulilyayo has failed to demonstrate that the trial chamber erred in finding that the actus reus of aiding and abetting genocide was established. As to the mens rea, the Appeals Chamber notes that Mr. Ntawukulilyayo personally observed the situation at Kabuye Hill shortly before the killings took place there on such a large scale. Mr. Ntawukulilyayo also issued his instructions to refugees at Gisagara Market to move to Kabuye Hill just hours before the attack took place and only 2 days after President Cindy Kubwabo's public speech in Gisagara referring to the 1959 revolution. In addition, the Appeals Chamber notes that the trial chamber found that Mr. Ntawukulilyayo's activities after the Kabuye Hill attacks, namely his participation in security meetings and his instructions to local Gisagara officials to organize civilian security efforts, offered circumstantial corroboration of his involvement in facilitating the attacks on Tutsis at Kabuye Hill. In these circumstances, the Appeals Chamber considers that it was reasonable for the trial chamber to conclude that Mr. Ntawukulilyayo knew that by instructing the refugees to move to Kabuye Hill and subsequently bringing soldiers there, he was assisting the assailants in killing the refugees, and that he knew of their genocidal intent. The Appeals Chamber also considers that based on the totality of the evidence in this case, evidence of Mr. Ntawukulilyayo's good character and assistance to other Tutsis did not preclude a reasonable trier of fact from concluding that the only reasonable inference was that Mr. Ntawukulilyayo knew that the Tutsi refugees would not, in fact, be protected at Kabuye Hill, but would rather be killed. For these reasons, the Appeals Chamber finds no error in the trial chamber's conclusion that appellant Ntawukulilyayo had the requisite mens rea for aiding and abetting genocide. Accordingly, the Appeals Chamber dismisses Ntawukulilyayo's fifth ground of appeal and the relevant part of his third ground of appeal. I now turn to Mr. Ntawukulilyayo's arguments on sentencing developed under his sixth ground of appeal. Mr. Ntawukulilyayo submits that the trial chamber erred in imposing a sentence which is clearly excessive, considering the limited nature of his participation in the crimes and the mitigating circumstances in this case. He requests that the Appeals Chamber significantly reduce his sentence. For reasons set forth in the judgment, the Appeals Chamber finds that Mr. Ntawukulilyayo has failed to demonstrate that the trial chamber committed a discernible error in affording insufficient weight to his mitigating circumstances. In light of the gravity of the crime, as emphasized by the trial chamber, the Appeals Chamber is not persuaded that the sentence imposed on Mr. Ntawukulilyayo was disproportionate to the nature and degree of his participation in the crimes as found by the trial chamber, and dismisses his arguments in this respect. The Appeals Chamber therefore dismisses Mr. Ntawukulilyayo's sixth ground of appeal. However, the Appeals Chamber recalls that it has found that the trial chamber erred in holding appellant Mr. Ntawukulilyayo responsible for ordering the killings perpetrated at Kabuye Hill. The Appeals Chamber considers that this calls for a reduction of his sentence. It notes, nonetheless, that it has affirmed his conviction for aiding and abetting the genocide of Tutsis at Kabuye Hill. Thus, Mr. Ntawukulilyayo remains convicted of an extremely serious crime. I will now read out the disposition in this case. Mr. Ntawukulilyayo, would you please rise? For the foregoing reasons, the Appeals Chamber, pursuant to Article 24 of the Statute of this Tribunal and Rule 118 of the Rules, noting the written submissions of the parties and their oral arguments presented at the appeal hearing of 26 September 2011. Sitting in open session grants Dominique Ntawukulilyayo's fourth ground of appeal and reverses his conviction for ordering genocide in relation to the killing of Tutsis at Kabuye Hill. Dismisses Dominique Ntawukulilyayo's appeal in all other respects. Affirms Dominique Ntawukulilyayo's conviction for aiding and abetting genocide in relation to the killing of Tutsis at Kabuye Hill. Sets aside Dominique Ntawukulilyayo's sentence of 25 years of imprisonment and imposes instead a sentence of 20 years of imprisonment, subject to credit being given under Rule 101C and Rule 107 of the rules for the period he has already spent in detention since his arrest on 17 October 2007. Rules that this judgment shall be enforced immediately pursuant to Rule 119 of the rules, and orders that in accordance with Rules 103B and 107 of the rules, Dominique Ntawukulilyayo is to remain in the custody of the tribunal pending the finalization of arrangements for his transfer to the state where his sentence will be served. And that concludes today's sitting. Please now distribute the copies of the written judgment. Thank you. Before we rise, I would like to thank all the staff members and others that have helped in the organization of today's sitting. I think we stand adjourned. Thank you.
All rise.